Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate and guardianship. Today's topic, I want to take you from the basic estate plan to an asset protection plan. All day today I was in an estate planning seminar or a webinar. So I've mentioned before that I'm part of a number of national organizations, and one of which is the National Association of Attorneys for Alzheimer's Planning, right? And in January, I was in Arizona at a week-long seminar, and the very next seminar should have been in September in Chicago, right? That's the way they scheduled it out. Now, I'm appearing virtually at a webinar. So I got to see a number of my colleagues from across the country. I saw them through an online platform, and it got me thinking about a number of topics. We really hit some of the basic documents, some of the more advanced documents, and then some of the thought process that goes into planning. So one of the takeaways is that every person needs a basic estate plan, right? The financial power of attorney is a very important document. It could really be the most important document for estate planning when properly completed, and when it has enough forethought, it can avoid guardianship cases. It can help you properly plan for Medicaid applications, and it's really quite a powerful document. Now, the basic estate planning documents really should include the power of attorney, healthcare proxy, advanced directives, such as a living will, and a will or a trust. A will-based plan would be your most basic. A trust-based plan would be maybe the next level up, and then a trust-based plan that includes asset protection and Medicaid planning. That would probably be your best bet if you have enough time and your circumstances warrant it, right? It's not a one-size-fits-all. It's what size fits your body and your situation. So I'll leave you on this thought. An asset protection plan takes your basic documents and pumps them up a little bit, right? Just goes a little bit further, a little more comprehensive, a little more, I don't even want to say thought is put into it, because the basic documents, there's an awful lot of thought put into those as well. But the thinking on the advanced plan is thinking outside of the box, expecting the unexpected. Expecting the unexpected. I had two different instances that really drove home the need for me for estate planning. On Friday, I was involved in an email thread, and one of the attorneys was a little bit more erratic than usual. This is the type of attorney that is always on the verge of being anxious, nervous, jumping in full-throated, head first, feet first, just jumping into the fray. And today, that attorney sent an email to the thread saying that he was recently diagnosed with a mental health condition, and he apologized. And that was really the extent of it. But it gave me pause, and to think that this attorney, was diagnosed with something, maybe is in need of medication, and that, was first of all erratic, and now disclosed this mental health condition, maybe to the detriment of his clients. Certainly, it was appropriate for him to say and to disclose, and I think he issued an apology. Right? So let me put a pin in the end of that little story. And then I have a client that I have been working with to plan for an entire estate plan. The things that are necessary to go from this client to his heirs. And I'm using a trust for the bulk of the transfers, right? There'll be some other work that we do in terms of changing beneficiary designations, changing ownership of life insurance policies and such. This person had been in remission, and now there's the onset of an illness again. So it just goes to show you that you never know. You really don't know, and the more things change, or the more they stay the same, the more things change. I don't know, expect the unexpected. Get your house in order. Figure out what's important for you, for your family, and how you can set up a plan while you're healthy, vibrant, mentally sharp. Well, certainly when a person is young, there's no pressing need, right? Historically, culturally, when do people get estate plans? Well, they think about it at least maybe 3 times. When they have children. When a person has a child, they will think about their mortality. What should happen to them in the event that they pass away and they have a child. So people think about it. Maybe they'll get a life insurance policy. Maybe they'll think of an estate plan. Another time is if someone close to them passes away, and they'll think about it, right? Especially if that person didn't have an estate plan, or there's a problematic situation, people fighting over an estate, something, right? So when it hits close to home, that's when people think about it. And then the third time, just generally, would be as they get older. And it doesn't have to be older, but when you hit a health crisis. So the person that that had gotten a heart attack or had a stroke or had some kind of illness, they'll think about an estate plan. But the young, so let's talk about it. Certainly, a 20-year-old is less likely to need an estate plan than a 60-year-old, just statistically. And we know that disability insurance and life insurance and the cost of these things are less expensive for a young person. However, there's not a 0 chance that someone will die at a young age. Right? There is a chance. And that's not even speaking about death. Well, no, I am speaking about death. I mean disability or incapacity. So for those reasons, a young person needs even a basic plan. So if you are younger or have a young person in your life, please think about it. Anyone over the age of 18 can and should have a plan, even if it's a basic plan. It doesn't have to be expensive. It doesn't have to be complicated, but it should be in writing and it should be done through an attorney. I actually have a young adult package on my website. I actually forgot about that as I'm speaking. It's geared for a young person that maybe they have a power of attorney, a healthcare proxy, and a will. So take a look at it. It's on my website, frankbrunolaw.com. 3 takeaways on how you can protect a lifetime of assets from the high cost of nursing homes. The first takeaway is to plan early. As you reach a mature age, you may need a nursing home, and I want your assets protected. The second takeaway is to update your beneficiary designations. Take a look at your bank accounts, your life insurance policies, your annuities, your stock, bond, brokerage accounts, and make sure it's the beneficiary that you want for today.
The third takeaway is to review any plan that you already have. You may have set a plan years ago, and it's not a set it and forget it. It needs to be reviewed.
What are the 3 types of asset protection? Before I get to that, welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law, estate planning attorney, probate attorney, guardianship attorney. Elder law is the catch-all phrase, guardianship, probate, and estate planning. Today's topic, what are the 3 types of asset protection? Generally speaking, you might want to protect yourself against bad decisions. Either the bad decision of a child, a spouse, or a grandchild. So maybe you might want to entrust money to a child, a grandchild, a spouse. And what about their bad decisions, or perhaps mistaken decisions to fritter away the money, a couple of bad choices, different asset vehicles, and all of a sudden we have issues. The second type of asset protection would be to safeguard assets so that you can apply for public benefits, right? Government benefits maybe in the Medicaid arena. That's the second type. Third type, generally, would be against lawsuits. So whether you are involved in a lawsuit for a personal injury claim, or from a creditor for a bad debt, or a business lawsuit. People sue for all sorts of reasons. Slip and fall in front of your home, slip and fall in front of your place of business, a consumer suing you, a vendor suing you, a business partner, right? So just protection from lawsuits. So I use the techniques that are involved, the strategies that are involved in asset protection, and protect your assets. Elder law estate planning has a mindset and a view to protect the person that's giving away his assets or her assets, and protecting the legacy of the person that's writing an estate plan. Right? So 2 instances where estate planning come into play. One is the commonly thought of when you pass away, what happens to your estate, and what is the plan for your estate. And your estate is all of the things that you have, from personal property to real property, intellectual property, money in the bank, stocks and bonds, all of the things that you have, personal property, the couch, the computer, all your things. So the estate plan is, what is your plan for those things, the stuff of your life? And the other instance is, should a person face an incapacity, dementia, Alzheimer's, brain injury, car accident, stroke, what happens? Well, that's how, with the focus on being an elder law attorney, I protect that person through the use of powers of attorney, healthcare proxy, living will. How do we safeguard that person and that against that possible scenario? Now, it does typically affect an older person. That's the elder in elder law. However, every person at every stage of life really could use a plan, because tragedies do not only befall the old, the elderly, the senior population. We have tragic events that occur, car accidents that occur for the younger people with young children, and we need to guard against that as well. So that's elder law, estate planning 101. Many people don't plan because they think they don't have enough assets. They don't have enough money to really make a plan. Or they mistakenly believe that the assets will be split among their children. Now, depending on what you have, where you have it, perhaps that is the case. I don't know your situation, but I will tell you that if you don't have a plan, you're going to follow the government's plan, right? The laws of intestacy. And it may be that the asset distribution is not the way you would have wanted it to be. So, if you pass away without establishing a plan of any kind, you leave it to chance, you leave it with the hope that the children will work things out, and they have to go through probate. Well, no, scratch that. If you don't have an estate plan, they'll have to go through an administration, which is it's the process that takes place in the surrogate's court for people without a will or a trust. So you have to go through that process. It's a public process, it's a court process, and you follow the rules of the road as laid down by New York State. And if you have a boyfriend or a girlfriend, they don't inherit. If you have a non-blood, really close relationship, they cannot administer your estate. Legal in the eyes of the law, they're a stranger. So if you want any of your money to go to charity, that can't happen. So there are reasons to have an estate plan. If you need to speak with me about your situation, please go to frankbrunolaw.com. Schedule an interview, read a blog post, watch a video. Any way that you can become familiar with perhaps the remedies that could address your situation. Thank you very much.
Friend, father, lawyer, call Frank